Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain and I am your host for the next hour. As our viewers are aware, the Free Legal Advice Show is designed to assist you with any legal matters that you have arising. It gives you the opportunity to call in to the studio and speak to me live with your question. If you do not wish to call into the studio but however still have a question that you wish to present, you can do so by sending it through on the WhatsApp number. Both of those numbers are at the bottom of your screen. The aim of this show is straightforward, is to provide a service for our viewers to understand their legal issues and to provide some guidance either by answering the question where that's possible or for me to take some further details and to call you back when the opportunity arises after the show to take some further details from you and provide some more detailed guidance. It is a free legal advice show. Any advice that you receive is free of charge. That's whether it's done during the show or if I need to call you back after the show. I have had some questions about presenting questions in Urdu. If you feel that you would prefer to present your question in Urdu because you can express yourself better, then please feel free to either type your question in Urdu or to ring the studio and speak to me directly. Again, I will provide your answer in Urdu and also in English. So please don't be afraid if language is a barrier or if you feel that you can explain your question better in the Urdu language. Any issues that you have must relate to the law in England. I'm not qualified in other jurisdictions and so I would not be able to assist you in regards to any queries engaging foreign jurisdictions. However, the question can relate to a broad category within English law. So it could be an employment law question, an immigration law question, a criminal law question, or any other field where English law applies. I do already have some questions, and as always, I thank our viewers for taking the time to put your questions through, and inshallah, I will endeavour to give you the fullest answer during the course of this show. If I do miss anything, or if I've misunderstood your question, then please feel free to either ring back or to supplement your question with another one on our WhatsApp group, and I will then elaborate further for you. So the first question I have here is from a sister. She asks, my marriage broke down after 8 years. There are 2 children and they live with mum. The husband is currently residing in Pakistan. If he wishes to apply to come to the United Kingdom or to live permanently on the basis of children, what chances does he have? For the viewers that watched my show a couple of weeks ago, I had a similar question and I was able to provide an answer at that point. It would depend on the circumstances of the particular case. So the husband, if he is seeking to come to the United Kingdom on the basis that he has British children here, he would need to demonstrate that A, he's not in a relationship with a partner where he can apply under a partner route. If he's not, then he can move forward to look at the parent route based on children. The father would need to demonstrate that there is a family life between himself and the children. So just a biological relationship in itself may be insufficient for that application to succeed, particularly where contact between parents is not amicable and there is animosity within that relationship. One parent doesn't want the other parent to have contact with the children, so mum doesn't want father to have any contact with the children. The children are very young, so the parents will need to make that decision. The best course of action would be to apply, to speak to the mum and to come up with some kind of arrangement where children can have contact with dad. That may, to start with, be contact through modern means of technology. So it may be Skype or other video conferencing means. It could be by telephone or a variety of those options. until those children have built up a relationship with the parent. It may then be that if there is established contact and there is a family life between the children and the father, then he can apply to come to the United Kingdom on that basis. But as I said, it needs to be more than a biological relationship, and there needs to be a demonstration of a private life. If, however, mum is not in agreement and there isn't an agreement between the two parties, so mum and dad cannot arrange contact with the children, then the dad may look to the family courts to obtain a court order, a contact order, whereby the courts would arrange for contact and make arrangements for the contact to be facilitated. The court can define how that contact takes place, so the court may restrict that to telephone calls, the court may restrict that to video calls. Doesn't necessarily mean that dad will be permitted to come to the United Kingdom. And again, it will depend on the specific facts of the case, whether or not the children already have contact with dad, whether or not they want contact with dad, and how long it has been since dad has had any contact with his children. The family courts would probably want to glean why dad has suddenly decided to have contact with his children, particularly if there's been a long period of absence. And again, the family law courts are very reluctant and hesitant to make contact orders where they feel that the true purpose of that application is not contact with children or a relationship with children, but that the true purpose may in fact be to facilitate an entry clearance application into the United Kingdom. And so you may find that if you are having to knock on the doors of the courts in this country to have some kind of contact order in place, you might not be granted that. You might be granted an order, but it may be restricted and therefore may not entail an application to the UK for you to have presence in the United Kingdom. If, however, you are successful in applying for entry clearance to the United Kingdom and you arrive here in the UK, then the likelihood is that you would be granted limited leave for a period usually of 2.5 years, and that would lead to settlement over a period of 10 years. And again, the Home Office will be interested in seeing evidence demonstrating that father has had an active involvement with the children and that this has not been an application purely to facilitate father's entry into the United Kingdom using the children as ammunition to do that. But it has in fact been a genuine application in order for him to build a relationship with his children and to have contact with his children. But if father does enter the United Kingdom on that route, then he could eventually achieve settlement subject to meeting all the requirements, but usually, as I say, after a period of 10 years. I hope that answers your question. It did say there were 2 questions, but I can only glean that there is 1 question in the message. So if I've missed anything, please do follow that up with a follow-up question. Again, if I've misunderstood your question and that wasn't the question you were asking, likewise, please do send a follow-up question through and I will then elaborate on that further for you. In terms of the next question that I have, this relates at the moment to an English language test. It's in relation to an immigration matter. Again, to facilitate an entry clearance application. So this is somebody arriving from outside of the United Kingdom. They are wanting to apply for a spouse visa. And they are wanting to understand what the requirements for the English language are and whether or not there are any exemptions to that. So anybody between the ages of 16 and, or in this case, 18, because you can't make a spouse application if you are under 18. So anybody in between the ages of 18 and 65 is required to demonstrate that they have sufficient command of the English language. And the Home Office has published policies on this. that there are specific exams, so there are Home Office approved exams, so anybody undertaking such an exam must ensure that it is an exam that will be accepted by the Home Office. Second of all, it has to be at the right level. So for a spouse application for entry clearance purposes, the level is A1, which is the most basic of levels. But that the applicant will need to demonstrate that they do have a certificate with the relevant exam provider at the relevant pass rate. In respect of any exemptions, then there are limited circumstances when an exemption can be provided, one of them being age. If an individual is over the age of 65, then they will be exempt from the English language test. The other exemption usually relates to health. If an individual has a severe health problem, generally a mental health problem, but it could be a physical health problem, but it has to impact on cognitive ability, the ability to learn, retain information, and to provide exam. So not just generally that I struggle with learning, or it might take me a little bit longer, a lot longer. It has to be a cognitive illness or a mental health illness which prevents the applicant from actually ever undertaking that exam. And again, generally, if it's a short-term diagnosis and this is something that will pass and the applicant will be able to take the exam, then the Home Office would expect the applicant to wait until they are fit enough to take the exam, for the exam to be completed, and then for the entry clearance application to be made. So they are the two exemptions, so age and the health. Otherwise, an English language certificate will be required to the requisite level and from the approved provider. And it's absolutely essential to ensure it is an approved provider. So I hope that helps with your question. We are going to proceed to a short break. Please continue to send your questions through, and I will inshallah answer them on the other side of this break. I'll see you shortly. Join me again. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain and I am your host this evening. Before we went to the break, I had started answering questions from our viewers in relation to their legal matters. If you have a question, then please feel free to either call me directly in the studio. You can present your question either in English or in Urdu, and I will then answer that for you again in Urdu and or English. If you feel that you do not wish to speak to me live on air, you might want to send your question through our WhatsApp group. You will find the number at the bottom of the screen. Again, you can present your question either in Urdu or in English, and I will get through that this evening for you. Just some guidance and tips on sending your questions through. Just ensure that the question provides sufficient detail for me to understand what your legal query is. And also provide me with sufficient detail about the question so that I can understand fully and give you a detailed answer. If I feel that I do need more information, I may take your details and contact you after the show, just so that I can give you a more accurate response to your question and the guidance that you need. I am going to move on to some further questions that have been sent through. Inshallah, in the meantime, if you want to send through your questions, I will come round to them. So the next question I have is, my missus came to the UK 11 months ago. Can she claim benefits when she gets her stay after 3 years? With the biometric card, it says that she is no recourse to public funds. That is correct. So anybody arriving in the United Kingdom on a spouse or partner, on the partner route, will have a condition endorsed against their stay, which states that they have no recourse to public funds. And what that generally means is that they're not entitled to claim welfare benefits in the United Kingdom. They are, however, allowed to work. So work is permitted. And the applicant, on the individual arriving in the UK, is free to find find employment and earn an income. Again, just on a side note, the individual will have paid the immigration surcharge, the health immigration surcharge, and therefore they are entitled to access medical health services because they've paid for that prior to arriving in the United Kingdom. With regards to whether or not your spouse can claim benefits after 3 years, then generally no. A spouse route would lead to settlement after 5 years, with renewal at the halfway point, so 2.5 years. Then you renew for a further 2.5 years, which will be subject to the same condition of no recourse to public funds but work permitted. And upon completing 5 years, subject to your wife meeting the requirements for indefinite leave to remain and settlement, she will then apply for that. If she is then granted settlement or her indefinite leave to remain, then she's a settled individual in the United Kingdom, and then she is entitled to access public funds. There won't be any conditions on her stay because she is considered to be settled. So in short, the answer to your question is no, she will not at the 3-year point, but she will do at the 5-year point as long as she qualifies for indefinite leave to remain and achieves settlement. If for some reason she doesn't meet the requirements for settlement and her leave is extended further and she's granted a further period of limited leave, then the condition of no recourse remains. And so that will stay as it is until she does achieve her indefinite leave to remain. I hope that does answer your question, and thank you for sending that through. I have another question which I will move on to. The questioner asks, I am a British citizen, a pensioner. I married a Pakistani citizen lady in 2018, so 3 years ago in Pakistan. I came back to the UK in June 2020. I have health issues. Can I call her here? Thank you. There is a route for partners or spouses in this case to join their British spouse in the United Kingdom. The immigration rules provide for that. There are requirements, however, that need to be satisfied in order for the applicant to be successful. So in terms of the requirements, there's a requirement that you have met each other, which clearly if you were living together in Pakistan, you will have done. That you are lawfully married. So if you had any previous marriages, those marriages ended permanently either by way of divorce or by way of death. If you are widowed or you were widowed, then you would need to provide evidence of that. There is a requirement to demonstrate that this is a genuine and subsisting relationship, but there's also a financial requirement as well as an accommodation requirement. Now, with regards to the financial requirement, you mentioned that you are a pensioner, so presumably in receipt of some form of a pension, either through pension credit or a private pension. If that's your only income, then you are required to demonstrate that you have an income base of 18,600 per annum. That's gross income, and that could be made up of various sources. If your only income is your pension, you may wish to rely on savings, and there's a wonderful formula within the immigration rules which allows you to calculate the amount of savings in addition to your pension that you will require. It usually takes into consideration the shortfall, so it takes away your income from the 18,600 requirement, and then there's various multiplications that you would need to calculate to come up with the final sum. You do mention, however, that you have health issues. I don't know what health issues, you've not specified that in your question. However, if you are in receipt of any disability-related benefits, for instance, personal independence payments, or if you were on disability living allowance and that still hasn't it's crossed over to the personal independence payments, then there is an exemption from meeting that 18,600 per annum financial requirement. There is a different financial requirement to still satisfy, but it's not as onerous as the 18,600. So again, some further detail would be helpful in respect of your inquiry, but it really does depend on your financial circumstances and whether or not the pension is your only income, or whether you do have other benefits such as the personal independence payment or any other disability benefits, which would lead to an exemption of meeting that higher financial requirement. But the question is, can you invite your wife to the UK? The answer is yes, you can, subject to meeting the requirements of the immigration rules. I suspect your question was in relation to the financial requirement, but I've highlighted some of the other requirements just for your information there, and I hope that that does answer your question, and good luck with that application. The next question is, I was married. My children are married and live separately. I was divorced in 1998. Oh, forgive me, I think this may be an extension of the same question that I've just answered. I think there's more details being provided, forgive me. So I was married, my children are married and live separately. I was divorced in 1998. My wife does not speak English. I get pension of £825 per month. I am taking medication for angina, diabetes, cholesterol, and now I have arthritis as well. I am 70 years old. I live here alone in a 3-bedroom house. I notified the pension department about my marriage, but did not make a claim. This divorce was done in the UK courts. The house I live in is my son's house. Right, so that does provide, again, you don't seem to mention the key information. You do mention the significant health difficulties that you are experiencing. However, you don't mention whether you get any related benefits, particularly now that you have arthritis, whether or not that impacts your mobility, cholesterol, angina, again, whether or not that requires some personal care. The key, as I say, is in respect of your income, as to whether or not you are in receipt of any of those qualifying benefits that then exempt you from that higher financial requirement. If you are not, then make inquiries about your entitlement to these benefits, because by the sounds of your difficulties and the extent of your difficulties, it may be that you are entitled to some additional benefits. And so the best place to do that would be your local Citizens Advice Bureau, because they will be able to do a full welfare benefits check for you and even assist you with making those applications. If, as I said, your only income is the pension at £825 per calendar month, you clearly would not meet the 18,600 per annum. You would then need to supplement that with either savings or another form of income that you may have. Otherwise, unfortunately, you don't meet the requirements, and it would be difficult for your application to succeed. You also mentioned that your wife does not speak English. It is a requirement of the immigration rules, as I said in the question prior to yours, that the correct level of English must be demonstrated unless your wife is over the age of 65 and is therefore exempt, or if she has her own medical difficulties which prevent her from taking that test. So a couple of issues there. You also mentioned that you are the house you reside in belongs to your son. That's not a problem. The immigration rules do not require that you own a property in the United Kingdom. Adequate accommodation for the purposes of the immigration rules is defined as accommodation which is exclusively for your use. This could be rented property. It could be a room in somebody else's property, such as a room in your son's home. Obviously, in your case, you have the entire house to yourself. So I'd say that the accommodation in your circumstances is adequate for the purposes of the application. So 2 issues for you to look into. the financial requirement, and if you're not already on welfare benefits, then to consult with your local Citizens Advice Bureau to see if you can. And then the other one is the English language test. We are going to a short break. Inshallah, we'll continue to answer your questions when I return. Please do continue to send your questions through as well. And inshallah, I will see you shortly. Join me then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am Riffat Hussain and I am your host for the remainder of this show. Just before we went into our break, I was answering some questions sent through by our viewers, putting their legal issues to me and receiving a response and some guidance as to their options. If you have a question relating to English law and would like some would like some answers even to your questions, then please feel free to either ring in on the landline number at the bottom of your screen or send through your question on our WhatsApp group, and I will pick those up in today's show and try and get through all of them as quickly as I can. There are a lot of questions, and if I don't get through your question today, then inshallah I will be back next week, so tune in then and I will continue to answer your questions. So I have a question here. I have a question, please assist. If you're the father of a British born child, and when the child is 7 years old, can his father apply for permanent stay? And to get permanent stay, does the father have to be in the UK, or can he apply if he is living in another country as well? What are the requirements? Can you please explain? So it's an immigration law question in relation to making an application for a British child, or making an application based on a British child in the United Kingdom. It's relatively similar to the question I answered earlier in the show. Again, it depends on the particular circumstances. But just because the child is a British citizen or has reached the age of 7 years in the United Kingdom does not entitle the father to apply for permanent residence. The father may be entitled to apply for limited leave to remain, but not and eventually for permanent residence, but not permanent residence outright or immediately when the application is made. It doesn't really say much about your relationship with your child apart from the biological relationship. So your father and son, it doesn't tell, your question doesn't tell me whether you have any contact with your son. You mentioned that the son is at least 7 years old because you say that he's been living here for 7 years. So again, if you were tuned in when I answered the question earlier, it may be a question for the authorities to ascertain why are you seeking to make this application. Are you seeking to make this application because you want to either regularize your status in the United Kingdom because you have no status, and this is the only way you're going to achieve that, or are you seeking to get into the UK on the basis that you have a child here? And again, if the authorities believe that you are abusing your biological relationship, and this isn't about you and your son, but more about you and your entry or settlement in the United Kingdom, then there may be that the Home Office may be minded to refuse your application. But certainly, in response to your question, can you make an application for permanent residence immediately? Then the answer is no. What are the requirements of the immigration rules? Again, quite complex. I answered these earlier. The first thing the Home Office will look at is that you're not entitled to make an application in the partner category. If you are in a relationship with somebody in the United Kingdom, or even the mother of your child, then you must engage the partner route first. If you do not meet the requirements for the partner route, then you may look to make an application under the parent route. How you make the application, what type of application you make, will depend on your location. So it'll depend on whether you are in the United Kingdom, it will depend on your status in the United Kingdom, or if you are outside of the United Kingdom, your location and the route that you can take into the country. So with the information I have, the answer is no, you can't apply for permanent residence just because your child has turned 7 years old. You may be entitled to make an application for limited leave to remain. What the requirements are will depend on your particular circumstances, which I'm not familiar with at the moment. But I hope that gives you some kind of guidance as to your inquiry. If you do want to follow that through with some more information, then please feel free to do so, and I can give you some more information. I have another question which I will move on to. So the question is, Assalamu alaikum, alaikum assalam wa rahmatullah. You say, I am a British citizen. My wife has been here over 2.5 years. I've applied for her extension. Her fingerprints have been done. I want to know how long will it be before I get to know the decision. Thank you. So thank you for your question, brother, and thank you for taking the time to send that through. With regards to decisions from the Home Office, at the moment, there are horrific delays at the Home Office. So applications of this nature would normally take up to 6 months. I am aware of applications taking between 9 to 12 months routinely, and some applications taking longer than 12 months. Don't be alarmed by that. It's not the fact that there's a problem with your application or a problem with your wife's continued leave in the United Kingdom. The issue is genuinely with the Home Office, where they are short-staffed. There are difficulties within various departments, and that is resulting in quite significant delays pretty much across the board at the moment with all types of applications. Some of them widely reported, such as the European Settlement Scheme, tens of thousands, almost now hundreds of thousands applications outstanding. Similar situation with asylum applications, and certainly applications under the family and private life routes are also subject to significant delays. Courses of action you can take: contact the Home Office at regular intervals, so usually about 3 months mark is a good kind of time frame to work with. You don't want to hound them. You don't want to kind of write to them weekly or even monthly. With a lot of these departments, the turnaround time with post is usually 28 days. You don't want to be writing to them every month because by the time they've caught up with your previous letter, you've already sent another one, and you're not going to get a response. 3 months is a good kind of time frame, and it's reasonable to then ask for an update at that point and say, I've waited patiently for 3 months. Can I just have an update? If it starts to get particularly lengthy, if you've been waiting over 6 months, you may wish to involve your GP, the MP. They can also write to the Home Office and seek an update for you. Again, generally, they tend to get a template response to say the application is pending. Some of them do get a decisive response from the Home Office. They give you an idea of roughly when your application may be decided. If you don't want to approach your GP, you might want to, depending on the length of time that you've been waiting, you might want to pursue a formal complaint with the Home Office. It's an online form that you can fill in. It goes to another department, a complaints department. Generally, my experience is that nothing much happens with your complaint. They will probably write back and say, there are delays, we are working through it. It's not been an unreasonably lengthy period of time that you've been waiting. However, in my experience, it also then generates a result. So even though your complaint is not upheld, you may find that within a few days or a week, you do get a letter from the Home Office with a decision on your application. So you may want to do that. Again, approach with caution. You don't want to be unnecessarily harassing the Home Office. You don't want to push them into a corner where a hasty decision is then made on your application, because it may not necessarily be a good decision. Remain reasonable, remain calm, but do pursue your options as you go through. So I hope that does answer your question, but in short, don't be alarmed. Unfortunately, this is the story for most applications at the moment, and there are quite significant delays. So thank you for sending that through. I will now move on to my next question. The question is, Assalamu alaikum, alaikum assalam wa rahmatullah. My mother is 89 years old. She is from Pakistan and staying with me since 2014. She has been refused twice for indefinite leave to remain visa. Can you guide us to apply for her visa, please? So the question is in relation to the adult dependent relative application that you would be making. And generally the requirement is that these applications are made from outside of the UK. You have your elderly mum in the United Kingdom. You don't tell me much about your mum's health, whether she's a healthy 89-year-old or whether she has other care needs. But in short, the adult dependent relative route is for adult dependent relatives who require help and assistance with their daily personal care. And that is the key to these applications. It has to be there has to be a need for personal care, and that personal care cannot be provided elsewhere. So you can't find, for example, a nurse who you can employ in Pakistan to provide your mother with the care that she requires. You can't rely on other relatives, for example, or even hire maybe not a qualified nurse, but somebody else who can meet the needs for your mother in Pakistan. And it's only once you've demonstrated that the Home Office will then look at your application favourably. You do need evidence. You can't rely on simply saying there is no care facilities or there are no care facilities. There is nobody to look after my mother. It has to be me. You will need to provide evidence. Your mother came in 2014. She will have made an application at that point. Presumably she made a visitor application maybe. Refer back to that. What did she say on that application about her circumstances in Pakistan? She will have been asked about relatives and other family in Pakistan. Who did she say she had at the time? Are they still there? If not, provide an explanation, provide the evidence. If they are there but unwilling to provide care, then again, you need evidence to say that. The key is, though, evidence of the need for care, and evidence that can't be met in Pakistan. I will come back after this break to continue the answers. Please join me then. Thank you. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for all the messages that our viewers are sending through. It's always a pleasure to read them and try and provide you with guidance, to try and help with your legal questions so that you can move forward with confidence that you are going the right way and to have that knowledge to access your rights. I do have lots more questions to get through, so I'm going to proceed straight to those questions. If you are wanting to send a question through, then please do so. The numbers are at the bottom of the screen. Next question I have is, Assalamu alaikum, sister. Alaikum assalam wa rahmatullah. I am hoping to apply for a visiting visa for my mother and father-in-law. I have read the Home Office website pertaining to eligibility of applying for visiting visas. I am a home owner and will be able to show appropriate accommodation for those visiting. But I just had a question regarding the financial requirement, namely whether you know how much in savings I need to show to cover their travel and stay in the UK? Jazakallah. Barakallah feek, and thank you so much for sending that question through. It is quite a common question in the immigration field in terms of visit visas. There is no prescribed financial amount that the entry clearance officer will want to see in support of your application. By that, what I mean is that the entry clearance officer is not expecting for you to have a particular amount of money in your account. What the entry clearance officer is looking for is, do you have the means to financially support this travel if you are the sponsor? It may be that your mother and father-in-law are paying for their own trip, and that therefore they would demonstrate the financial requirement. But it depends on the circumstances. What are they coming for? Are they coming for a family visit and will spend their 6 months or whatever period of time in your family home around you and the rest of your family? Or are they going to be, taking a tour of the UK, for example? If they are going to be taking a tour of the UK, then you will need to demonstrate that you have sufficient funds to cover those tours. Are you going to be staying, or are they even going to be staying in hotels, for instance? Are they going to be booking into any attractions for which they need funds? So it depends on the circumstances. So if they are going to be taking a tour of the UK, their trip may cost them £2,000 or £3,000. If, however, they're just coming to spend some time with you and your family and will predominantly be staying in your family home with small excursions here and there, but not costly ones, then you're not going to need that a great deal of money. So it depends on the particular circumstances. And it's important that you explain that in your covering letter. The key thing with visit applications is, can it be afforded? So is there the money for the flights? Is there money for the accommodation? If accommodation is not provided by you, in this case it is, so there won't be any additional cost for that. Will you be providing for their essential living needs? Will you be providing the food and so forth? Again, if that's covered by you, do you have the means to be able to do that? And then, as I say, any additional monies that may be required for any additional activities that they may be doing. Generally, my experience is that with visit visa applications, the sponsorship and the financial issues are not the issues that lead an application to being rejected. The key reason for rejection in visit visa applications, irrespective of where they're made from, is whether or not the visit is a genuine visit. You mentioned that both your mother and father-in-law are coming to the UK. I know very little about their circumstances in their country of origin. Do they have other family? Do they have any other ties to their country? Because the entry clearance officer may conclude, if they are a couple living alone, they have no other family, they have no work, no other ties left in their country of origin, that they're not coming for a visit, that they have no intention of going back to their country of origin, because any ties that they have are now here in the UK, so there's no incentive to go back. So the focus with a visit visa application is, what do they have to go back to? What evidence can you produce to demonstrate that they will in fact leave the United Kingdom after their period of stay, their permitted period of stay as well, so that they're not going to become overstayers and then making other types of applications on the basis that they have care needs or that they cannot go back. So the answer, no prescribed financial requirement, just whatever is essential in meeting those costs, but a focus more on their position, their ties to the country, their financial circumstances in the country, that may be relevant as well. So inshallah, I hope that answers your question, and thank you for sending your question through. I have a caller, which I will go to before I move on to the next question. Assalamu alaikum. Hello, assalamu alaikum.
Wa alaikum assalam. You're talking to Madam Mohammed Aslam, former local government officer for Pendle Council. I work all my life in a social welfare voluntary organization. I used to specialize in immigration, but due to law changes, I've given up. I've got a lot of clients wanted some information support on immigration. If I make a referral to your company, yourself or Elias, I know him personally, would you mind that take some detail from me? I do want to work together in a partnership.
Brother, if you are aware of any clients who are needing legal advice, then like you said, you know Brother Ilyas, you have our contact details. By all means, forward them through to either myself or to Brother Ilyas. And inshallah, if there's anybody we can assist, then we will do so. But thank you so much for taking the time for contacting the show. If you do have any questions, or if any of your friends or colleagues have any questions that they want answered on the show, then please forward them through as well. Inshallah, I will now move on to our next question. Assalamu alaikum, sister. Alaikum assalam wa rahmatullah. Loved the show. Thank you so much. I had a question. I'm thinking of getting married in the coming months. My partner is not from the UK. I am a UK citizen. My future partner is from the UAE. What's the best way to go about it? Thanks. May Allah bless you. Ameen. And thank you so much. That's such a lovely message to receive. Inshallah, may everything go well with your upcoming marriage. So again, another immigration law question. The sister is, inshallah, getting married soon and is wanting to know the best way, presumably for her husband or future husband to join her in the United Kingdom. I touched upon the requirements earlier, sister. They are that you need to demonstrate that you've met your partner, your future husband. Obviously, the application is made after the marriage has taken place. It needs to be a lawful marriage in the country where it takes place. So lawful marriage in the country where it takes place, you've met each other, and that this is a genuine and subsisting relationship. It's not a forced marriage. It's not a marriage of convenience. It's a marriage that you both genuinely intend to live in. You also then need to demonstrate the financial requirements, which I touched upon earlier in the show. So 18,600 gross per annum. And also the accommodation requirements. So a room which would be exclusively used by you and your husband. That can be a home that you rent. It could be a room that you rent. It could be a room within your parents' home, for example. So there are a variety of options in relation to accommodation. Main thing is demonstrating that the requirements are met. There is an English language requirement, which is at the A1 level. So there would need to be an English language test. And that needs to be, the certificate needs to be provided with your application as well. There's also, with certain countries, the requirement to provide a TB test. And the Home Office does list the countries where that is required from. I don't believe that the UAE is on that, but you may want to check that. But inshallah, the best way to go by it is to ensure that you meet the rules, provide as much evidence as you can. So a copy of your marriage certificate, any photographs from the wedding to show that you've met, wage slips, bank statements, your property letter. So it could be a tenancy agreement or letter from family if you're living with family, and the various other tests that I've mentioned. So the English language, and if a TB test is needed, the certificate as well. The application is made online, sister, so you would do that online and pay the application fee. There is a Home Office application fee, and there's also the immigration health surcharge, which is paid at £624 per annum. That would be £1,560 because it is paid for the 2.5 years that your future husband will be granted entry clearance for. But I really do wish you all the best with that, and I hope that that does answer your question. I do still have some outstanding questions, brothers and sisters, and thank you so much for taking the time to send them through. I hope I've answered the questions that have been put to me thoroughly. If I have missed anything, as always, I remind you to send through a follow-up question, and inshallah, I will give you a more detailed answer. Any questions that I have missed this evening, then inshallah, I will pick them up next week and go through them in more detail. If I don't do that, then do send the question through again. There are two ways of participating in this show, as you all know. So the one way is to send through, that most people are using at the moment, is to send through your message on our WhatsApp group. Type out the message as full as you can do, so I've got sufficient detail to understand your inquiry and give you a detailed response. If you are able to, then please pick up the phone and speak to me directly in the studio. It helps me ask you further questions and give you more of a detailed answer. As I said at the start of the show, if there are any of our brothers and sisters who feel that they prefer to put their question in Urdu, then please pick up the phone or just type your message in Urdu and I will respond to that. We are unfortunately running out of time for this evening. That was the final segment. Inshallah, join me again next week on Monday at 7 p.m. where I will continue to answer your questions. Assalamu alaikum wa rahmatullahi wa barakatuh.